In this part of the course, I would like to briefly explore some of the main concepts that the GDPR operates with: personal data, data controllers, and data processors. This will help us establish a common ground and get familiar with the basic GDPR terminology. The GDPR applies to personal data. This is defined as any information relating to an identifiable person who can be directly or indirectly identified, in particular by reference to an identifier. Sounds complicated. The GDPR offers several examples of identifiers, such as name, identification number, location data, as well as online identifiers. In other words, name, contact details like telephone number, email addresses, passport number, image, voice, and even online IP addresses are all personal data under the GDPR. Companies can choose to key code personal data through a process called pseudonymization. However, the GDPR may still apply if, despite the key coding, the individual can be easily identified. A practical note on the definition of personal data under the GDPR. The wording is very general, so if in doubt, the safer approach would be to treat the data in question as personal data. Now let's look at some basic rules for processing personal data. Personal data should be processed in accordance with the principles set forth by the GDPR. Just to name a few, data must be processed lawfully, fairly, and in a transparent manner, as well as for legitimate purposes, but limited to what is actually necessary. There are 6 lawful bases for processing personal data: consent, performance of a contract, compliance with a legal obligation of the data controller, protection of the vital interests of the data subject or of another natural person, public interest, and legitimate interests pursued by the controller or by a third party. The key point to note is that all such bases for processing are equally valid. No basis is more valid than the other. This means that companies can decide which basis of processing is more suitable to justify their data processing activities, consent or legitimate interest, etc. Companies should only process the minimum amount of personal data necessary to successfully accomplish a given task. If processing personal data can be avoided, companies should go for that route. Sensitive personal data, or special categories of personal data, specifically include data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, or health data. Personal data relating to criminal convictions is now subject to tighter controls in a separate section of the GDPR. Sensitive personal data can be processed in limited situations set forth by the GDPR, such as when data subjects have explicitly consented, when processing is necessary in the context of employment law obligations, or when it is necessary to protect the vital interests of the data subject who is unable to give consent. To take an example from everyday life, if an individual consents to the processing of his or her health data by an organization in accordance with the GDPR requirements and consent, that organization is allowed to process health data on the basis of consent. But what does processing actually mean? Processing means any operation performed on personal data, whether or not by automated means or manual filing systems. The definition of processing in the GDPR is quite broad, so it seems to cover almost any operation your company might perform, from collecting and recording personal data to transmission, erasure, or destruction of personal data.